So, how do we establish whether a person acts as an agent on behalf of the principal or not? So, we need to start from practical perspective. When you're faced with a question in the exam, for example, or in practice, you need to determine whether a person acts on behalf of someone else. You need to then ask yourself whether the person of the potential principal has conferred authority on behalf of the person of the potential agent to act on their behalf. And that authority could be actually conferred, it could be actual authority. It's important to establish whether this legal relationship exists for at least two reasons. First of all, it's important to know whether there has been actual authority and what is its ambit, in order to know whether the person of the agent has acted outside of that ambit. That will have consequences. It most obviously will have the consequences of limiting the liability of the principal. If the agent acted without authority of the principal, from the principal, then the principal prima facie is not bound. We'll talk about circumstances where there might be exceptions to this. Now, actual authority is defined for us quite conveniently in Freeman and Lockyer Freeman and Lockyer by Lord Justice Diplock, which is an important case. And Lord Justice Diplock says that actual authority is the legal relationship between principal and agent. We know that internal relationship created by consensual agreement to which they alone are parties. Now, how do we establish the scope of this legal relationship, the authority? And Lord Justice Diplock tells us that we are looking at the ordinary principles of construction of contracts, if there is a contract, but not only that. We may look at the conduct of the parties, in particular prior conduct, implications from the words, but also usages of trade and course of business. And on that basis, we can determine the scope of actual authority conferred on the agent. Actual authority could be conferred on the agent in a very formal way, and that's usually by way of deed as a power of attorney. And there is a reference on the slide to the Powers of Attorney Act. And in practice, that's how it's very, very often done. The acts that you need agents for, which require deeds, must be concluded in the form of a deed by power of attorney, but vast majority of acts in practice will be such that you will appoint an agent using a power of attorney. So it's done in a formal way, and then if you need to determine the scope of authority conferred on the agent by way of power, again, it's a question of construction of the terms of the power of attorney, which confers the authority. And the principles of interpretation of this power, of the terms of this power that confers authority on the agent, will be quite strict. It's a formal document, so the assumption is that once you undertake a formal document, enter into a agency relationship by way of power of attorney, you know, both parties know what they're doing. So courts are not tempted to be very liberal with the scope of authority there. But more relevant from our perspective in terms of there being more scope for thinking about various aspects is authority conferred in a non-formal way, not by way of deed, That actual authority could be conferred in an ordinary document, but also orally. And if there is a question of the words in the grant of authority being ambiguous, then Lord Chelmsford in Ireland and Livingston tells us that in such cases, if the terms are uncertain, as to be susceptible to different meanings, so the agent does not know whether they are entitled to do an act for a principal or not. If the agent acts bona fide and adopts one interpretation, then the court will protect that agent. And as a result, the principal will not be able to argue that the act undertaken by such agent is unauthorized. Okay. Any questions on express authority? Now, implied authority is authority that we come across in a vast range of cases and circumstances. So, implied authority could be implied from course of dealing between the parties. Now, Healy Hutchinson is a very good example of this case. What were the facts in Healy Hutchinson? Anybody? So it was on the reading list, I think. What happened in Healy Hutchinson? So there was a director. There was a company called Braehead, as the case name suggests. I would very strongly urge you to read those cases beforehand to save us time. But very briefly, the facts were that there was a company of Braehead, and the managing director of that company was a person who acted as a de facto manager. He wasn't formally appointed. Healy Hutchinson, this person, was a chairman of another company which needed some finance. And there was a proposal put forward to the Braehead company whether Braehead would provide some financial assistance. And this de facto managing director, in fact, signed on behalf of Braehead company an agreement to put more money in, and it was a financial form of assistance to this other company. Now, the question was whether the company of Braehead, on behalf of whom the de facto managing director acted, was bound by this act. And the question arose, and it came all the way to Court of Appeal, because the director who acted wasn't formally appointed. The company did not formally agree to the scope of authority this director would have. In particular, the scope of authority to undertake financial commitments on behalf of the company. So the managing director the argument was not authorized to strike this deal, and therefore Braehead company would not be liable to pay. But the counter-argument was, well, there was no actual authority, there was no formal appointment, but the person acted as a de facto managing director. In previous course of dealing, the board of directors of Braehead were very happy with this person acting and binding the company of Braehead to various financial commitments and other contracts. So based on the track record of the previous dealings, they vested this director with implied authority. So it wasn't actually express, but it was actual implied authority. and it was implied from the conduct of the parties. Lord Denning tells us that the agent had authority implied from the conduct and the circumstances of the case. And it's important when you're faced with, either in practice or in an exam, with the question of whether an agent or person of the agent has authority, is to look at not only the express words used, but also the circumstances of the case. Whether the person of the principal against whom or whom the third party is suing, usually that will be the set of circumstances, but not necessarily. The question is whether the agent might have some form of actual authority, and it could be authority implied from conduct. Now, this is actual authority, and I do stress this. I urge you to read Healy and Hutchinson. It is really important case. Now, an agent might be interacting, or a person of the agent might be interacting with a third party, but actually not be authorised by the principal. So they might appear to the third party that they have authority, but actually not be authorised. And this concept is called, quite clearly, apparent authority or ostensible authority. Now, this idea of apparent authority has, in my view, very little to do with actual authority. So, and the majority view is that those two forms of authority are not comparable. So we need to spend some time talking about the nature of apparent authority. So when we talk about apparent authority, we talk about what the perception of the third party. Apparent authority, as Lord Justice Diplock in Freeman and Lockyer tells us, is very different from actual authority. It's created by a representation made by the principal to the third party, which is intended to be acted upon by the third party. Now, this sounds slightly dry, so I think we need some examples when the apparent authority might arise. And if you're wondering, by the way, why we have such long quotes, they are the quotes that are on the handout, especially from the key judgments that you were asked to read, are very handy, and they're there for a reason when you're revising and thinking about the principles. So don't rely on the secondary sources, of course, but you no doubt know that. So a basic example might help. And imagine that a person comes to an accountant firm and wants to discharge a debt that they owe to that firm. And they come into the office, they see someone sat behind the desk with a pile of accounting papers, and they say, "Can I pay this debt which I owe you?" And the person behind the desk says, "Yes, of course." The person who came in pays, and the person behind the desk takes the money. Now, the person who came in is our third party, stranger, who comes in and thinks that they have just discharged the debt. But what might happen is that this person behind the desk was a complete fraudster. They just came in, sat behind the desk, and they appeared to be acting on behalf of the accounting firm. But in fact they were not. And these were the facts of Barrett and Deere, in fact, a very old case. And the court held that, so the question was whether the accounting firm could argue that the person who came in to pay their debt could sue that same person again, because from the perspective of the firm, they never received the money. The fraudster, the rogue, took the money and absconded. So the firm is short And the court said that this debtor, the person, the stranger, must be protected in those circumstances because they came in thinking they are paying a debt to the accounting firm, and the accounting firm has created a set of circumstances which appeared, to all intents and purposes, as if the person behind the desk was authorized to accept the money. So the concept of apparent authority is, you can see that in action. Questions? Yep.
Yeah, would it make a good example of this be franchising? So say somebody starts a gym, they start a gym, and then they decide that they're going to sell the brand to other people who want to start up gyms under that very name, and then perhaps the people who go to those gyms that are set up by the people who bought the brand from the original franchise owner, they might think that they're interacting with like the sort of top of the tree gym owner, but in fact they're just talking to people who bought the brand name. At Starbucks as well, I believe that's sort of a similar franchising situation. So I'm just asking, is franchising a good example of where implied authority might occur?
Right, so we're talking about apparent
authority.
Right, so franchising could be an example of it, but it all depends on the facts and whether, or we could argue in line with the principles set out for us in Freeman and Lockyer, whether there has been a representation made by the principal to the third party that the person who appears as an agent is in fact an agent. So the concept of apparent authority is premised on the idea of a representation, conduct by the principal as it appears to the third party. Okay? In the example of the beer case with the accountant, the accounting firm, it was the accounting firm that created the appearance, made a representation to the third party that the person whom they allowed, they might not know this person, but this doesn't matter. They allowed someone to be in a position and as a person entitled to receive payment on behalf of the accounting firm. And by doing so, by allowing the set of circumstances to take place, they conducted themselves in such a way as to make a representation to the third party that the person behind the desk dealing with the third party is in fact an agent, even though actually this is not true. So franchising could be an example of it, but we'd have to examine a specific set of circumstances. And I think it's also, this question also leads us to another point, that with apparent authority we need to look at, usually the question is whether a third party could sue the principal. That's the usual set of circumstances when apparent authority comes into play. If the third party shows successfully that the principal has appeared, has made this representation, apparent authority can be relied on by the third party. From the perspective of, and this is very important, from the perspective of the principal as against the agent, the act is still unauthorized. Okay? Apparent authority just establishes a relationship between the third party and the principal, and it enables the third party customer coming in to pay a debt to discharge the debt and creates a relationship between the third party and principal. But from the perspective of the principal, the agent still acted in an unauthorized way, so the act is still unauthorized. That has consequences for the principal itself, because if the principal wanted to sue the third party for whatever else, then they might need to, they will have to adopt the act, ratify the act, in order to be able to sue the third party. Okay? So we had a question, I think, there first and over there.
So the external aspect of the relationship that is like from the third party to
Well, the internal aspect of the agency in apparent authority scenario would be initially non-existent because there is no authority. So it's a good question because it makes me add another point. It could be that the principal, like in the example I've just given, has never authorized the agent. They might not even know them, they've never seen them in real life. But it could be that they have authorized the agent, but the agent has exceeded authority or the authority just terminated. Okay, so there could be various reasons. But in apparent authority scenarios, the whole point is that there is no internal aspect yet, and it's within the power of the principal to change that, and they could do so. But the apparent authority, the point of apparent authority is that it's all about protecting the third party's interests, because the third party has relied on a representation made by the principal. And it's protection of the third party that we worry about here. I thought there was another question. Yep.
So can't you really call it imputed authority? Because the liability, more often than not, is still going to lie with the principal if the third party is aggrieved.
I don't think so, because if you say that it's imputed authority or implied or use some other word, then that would suggest that you're remedying the entire relationship between the principal and agent as well. Whereas apparent authority is very clearly not about principal and agent. It's only about the protection of the third party as against the principal. So the third party is protected and may sue the principal.
But you're still creating a fiction of authority in order to protect the third party.
Yes, and we'll come to the conceptual underpinnings of that. So there are other circumstances where representation could be made by the principal, even though they might not know, may not be in a actual. They might not be in a relationship with the agent, and there might not be any agency. One example we've touched on already, which is termination of authority, and an example of this is Summers and Solomon. These cases, by the way, the Beer case and Solomon case, they are just examples. So you're not asked to read those cases in detail. They're just there to give a little bit of flesh on the dry detail. So in that case, it was a straightforward case of termination of authority by a jeweler to his nephew, and the court decided to protect the third party who was not aware that authority of the nephew to deal with the jewels was terminated. A very common example appears in company cases, and a good illustration of this is in Lord Denning's obiter dictum. This wasn't the ratio of the case, but the obiter, in Healy Hutchinson and Brayhead, where he provides the example of a director who is authorized to enter into contracts on behalf of the company up to a certain limit. For example, all the contracts up to the value of £500 are authorized. The moment the director enters into a contract for 501, that contract is unauthorized. Agreed? There is no actual authority to undertake this act. But from the perspective of the third party, this might be a very harsh result if we follow this through. So the courts enable the third party in those circumstances to argue that the third party ought to be protected because the company makes a representation that the director is liable to undertake those acts, has authority to undertake those acts, even though they don't have actual authority to do so. And the third party has no means to find out up to which limit the agent is authorized. So it would be unreasonable to require the third party to go and ask the directors whether they are entitled to enter into contracts for £500 or 501. That would be quite uncommercial and not useful. So it's necessary to protect third parties. But we have to put a limit somewhere. Because there's surely a difference between a situation where the third party contracts with the director for, say, £501 and £1 million. So if the new transaction between the third party and the director is for a staggeringly large amount, then perhaps that should raise some bells in the third party. Can I just finish the segment and then we'll come to the questions? So the next question then is, to what extent we should require the third party to make inquiries into the extent of actual authority? Should we require the third party to be proactive? And if so, to what extent? And the rather lengthy dictum of Lord Neuberger in Akai Holdings tells us very clearly that the courts are not requiring the third parties to make any inquiries. There is no need to make inquiries that would be reasonable, unless they are very widely unreasonable, so as to be irrational, that no one else would act. But there is no requirement on the third party to make inquiries if it would be merely reasonable to do so. So, for example, the third party has means to inquire into the extent of director's liability because, for example, the third party has dealt with the director before, knows the director personally, and it would be very easy for the third party to make those inquiries. There is no duty on that third party to make those inquiries. The result is that even if a third party could check that whether the director or other agent is authorised or not, they don't need to do so, and they will be protected by courts in situations where the principal represented to that third party that the agent is authorised, even though in fact this is not true. Now, this approach could be critiqued somewhat, because if you think about the basic scenario of entering into a contract, okay, forget about agency for a second and just think about entering into a contract. When a person enters into a contract, first there's an offer and acceptance. How do you judge whether there is an offer made and acceptance? On what principles? You look at intention of the parties, but do you look at subjective intention, their actual intentions? You looked at objective, absolutely, objective intention, as it is manifested to third parties, to the world. You look at what a reasonable person would think of those intentions. So if in contract formation we have this requirement that we're looking at what a reasonable person would think about communication of the offer and communication of the acceptance, then why shouldn't we look at similar principles when we look at formation of contract entered into by agents? When an agent enters into a contract, somehow, if we follow through what Lord Neuberger says, the third party does not need to inquire, does not need to, their perception of the offer or the acceptance of the other party doesn't have to be reasonable. Okay? It will be binding even if it is unreasonable, unless it is so widely unreasonable that it's irrational. It's a slightly odd way of putting the balance, perhaps quite a lot in favour of the third party.
Is there any reason why third parties to such a large extent?
Well, one reason is that the third party has no means of checking necessarily whether they're dealing with the principal or not. So we're back to the question of whether we should require the third party to make the inquiries. And the general, the policy explanation would be that we want agents to be used in contracts because it's efficient. Why is that efficient? The point we made at the start, that it would be unreasonable for big companies, in fact any companies and businesses, to be worried about having to enter into contracts individually. It's more efficient and more commercial to have agents act on behalf of the company. So we want to encourage use of agency, and we don't want to discourage third parties from entering into contracts with the companies. On the other hand, you might ask, well, that's okay, but does this show whether the balance should be in favour of a principal or agent? Or a third party? Well, the principal is the person who creates this situation where the third party is exposed to the risk of potentially being liable to someone they don't know. They think they're entering into a contract with principal, but actually they're not. So it's the principal that creates this risk for the third party in the first place. And I think that would be the policy explanation. Yep.
So a sensible approach would be, and as supported by Lord Denning and Hughie Hutchinson, reasonable third-party perceptions of the agreement between principal and agent will dictate how much protection they receive as regards a defunct transaction.
Well, I think we might have to qualify that reasonableness in light of what Lord Neuberger said in Akai Holdings, because if you think about those reasonable expectations of the third party in light of whether they ought to make any inquiries as to the extent of authority that was given to the agent, then Lord Neuberger says, well, you don't have to make those reasonable inquiries. Unless the third party acted dishonestly, there was the case of fraud, something very serious, the third party doesn't have to make those inquiries, even if it is reasonable, which is why this is somewhat controversial.
So we could take from Lord Neuberger's comments that if they are keen to protect third parties so that essentially third parties don't feel too insecure in entering transactions for the betterment of the economy.
I think that would be the policy explanation. I think so. Okay. So, any other questions on this point? Yep.
In the contract between the agent and the principal, is it possible that there are any limitations to counter this exposure of liability? Because in this case, then any evidence drawn on the agent will be ineffectual.
Right, so when you say limitations on the extent of liability, which contract do you mean?
The internal contract between the agent and the principal.
Well, that will not affect the third party necessarily. So if we are talking about apparent authority, we are not worried about the contract between the principal and the agent, because apparent authority has nothing to do with actual authority conferred upon principle. This is what I mean when I say that apparent authority is very different and very separate from actual authority. So the limitations of liability on the principal in the contract with the agent, or limitations of authority between principal and the agent, are just between them. If the agent acted outside that authority, okay, two things might happen. First of all, the initial thought is that the principal is not bound. Agreed? No actual authority, principal not bound. But then, we have to ask the second question, is it possible that the third party could argue that a representation was made to them by the principal nonetheless, despite the lack of authority. And then any clauses in the contract between the principal and the agent will not have any impact on the extent of liability of the principal and the agent.
I think my question is like whether there's any limitations on the internal contract between the agent and the principal, or is this not
So I didn't hear the first part of the question.
the question is whether there's any limitations that can be drawn in the internal contract.
Right, whether you could do anything about it? No. No. That's good thinking forward, but no. So I think it's what I really like about commercial law is that a lot of it is about contract and about interpretation of contract. And we said in the last lecture that third parties like certainty, and we like to be able to know what the party's bargain is. And contract is the basis of it. But nonetheless, there are other principles in law, in general law, that will operate. And apparent authority is an example of it. A principle that will operate to balance the interests of the parties where necessary. And in fact, it is a very nice essay question to ask how the law of agency balances the interests of a principal and a third party, or principal and the agent, or agent and the third party. So contract may be a starting point, but there is more to the law of agency. Okay, so the next question then is it possible that the representation that the principal makes in apparent authority principles, doctrine, to the third party, comes only from the agent? So, in other words, can the agent make a representation himself or herself that they have authority to undertake an act, rather than this representation being based on the circumstances of the case and the conduct of the principal? So can the agent himself or herself say to the third party, yes, I'm authorised? And the general principle, the basic answer to this question is that the agent may not do that. It would go against, this would perhaps take the balance too much in favour of the third party, and away from the protection of the interests of the principal. Because any agent could come, and any person in fact could come to any other person and say, well, I'm authorised to act on this person, and the third party would be entitled to believe and be bound to a contract with the principal when they don't know anything about. And this principle comes, first of all, there are two interesting cases. The first is the Ocean Frost case, which involved a case of a sale of a ship. And in that case, one company was selling a ship to another company, and both companies had agents acting on their behalf. And the way they wanted to strike this deal wasn't a straightforward sale, but it was a sale and charter back of the ship to the seller, which meant that the seller would have the use of the ship for a period of time. And in order to do that, the charter party agreement was to be concluded. And those two agents colluded. They were fraudulent, in fact, and they entered into one contract, which is what both boards of directors of both companies agreed, which was a one-year lease agreement, charter party agreement. But there was also a second contract to which those agents entered into on behalf of the companies. And it was that second contract that was very clearly unauthorised from the perspective of the seller of the ship. So when the seller wanted to give back the ship to the buyer and say, well, it's yours now, And the buyer said, well, no, you wait a minute, you agreed to charter the ship for another 3 years. And that's when the question arose whether the seller was entitled to enforce the terms of that agreement against the buyer of the ship. And the question then became, is there a contract between them? That question in turn turned on the presence of the agent and whether the agent, on behalf of the seller, had authority to enter into the contract. They had no actual authority. That was clear. So the next question is, did the seller make a representation to the buyer that the agent had authority to do so? And the only way you could show this representation was by way of a statement by the agent itself, who said, yes, I have this authority. That was the only way in which this supposed representation could be shown. And the court rejected that. There are earlier dicta in Freeman and Lockyer by Lord Diplock, where he says that an agent cannot hold himself out to have authority. If you're very careful and if you carefully read the Healy-Hutchinson judgment, you will see that Lord Denning there says something which is quite opposite. But in the Ocean Frost, the Court of Appeal and then House of Lords were persuaded by Lord Diplock's judgment in Freeman and Lockyer and said that an agent cannot represent himself, therefore cannot enter into the contract on behalf of the company, therefore the company is not bound. There is no scope for apparent authority doctrine to apply. So a similar question arises in the First Energy case, which was on very similar facts, except in relation to acquiring a bank loan by a company who was undertaking various energy heating projects, and they needed finance from banks, from one bank in particular, to finance those projects. And they were dealing with a senior manager within that bank who was approving those loans on behalf of the bank. They did try to negotiate a general facility agreement to have a general access to larger funds, but this was not possible for various reasons. So that's why this company, First Energy, ended up asking for money for individual projects. And the senior manager approved those loans on behalf of the bank, usually with 2 signatures, and the loans were made available to First Energy Company. But then this other project came through, and the loan manager only produced a document showing 1 signature. And in fact, this was not a loan that was approved by the senior officials at the bank, by the board, or whoever it was, of this bank who approved the granting of those loans. So the granting of this one last loan was not approved by the bank, was not authorised. As a result, the customer sought to argue that the bank nonetheless made a representation to the client, to them, to First Energy, that the loan was approved and that the money should be made available for the project. Right, so the whole question came down to whether the bank should advance the money or not, whether they were liable to advance the loan, make the loan to the First Energy Company or not. And it looks very similar to the case we've just discussed, because it looks very, very much like the agent making a representation themselves that they are authorised. So you would expect that the court would follow the approach in Ocean Frost and say that this contract was not authorised and therefore the bank isn't bound. But an argument was made that this is a different arrangement, and the court managed to rule in favour of the client and to show that the counsel showed, and the court was persuaded, that there was an appearance of authority on behalf of the senior manager who dealt with the First Energy company. And this is quite important because the court said it wasn't an appearance of authority to grant loans, but it was an appearance of authority to communicate that the loan was approved. And that was sufficient for the third party to rely on that representation and for apparent authority to be found. And you might draw all sorts of comparisons between First Energy and Ocean Frost. One difference is that we're dealing in First Energy with a bank client scenario. So we're not dealing with a sale of an individual ship, a one-off sale and one-off charter party contract, where perhaps you don't expect the agent who's negotiating those contracts to also be authorised to do all the other contracts. But in a bank scenario where the bank is dealing with a client, the client is entitled to assume that the senior manager has authority to communicate approvals of those loans. And what other options are there open to the client? In Ocean Frost, we might say, if any of the parties were worried, they might check with the board of directors with the company, the other company, whether the agent is authorised or not. But when a client company is asking for money, it would be very uncommercial for the company asking for a loan to say, well, I don't trust your senior manager, dear bank, can you please verify this for me? So that is perhaps another distinguishing factor. Okay. Do you have any questions on self-authorising agents? Yes?
This idea of self-authorising agency, which then leads to liability for the agent rather than the principal. Well, so you've got a financier who's given a considerable amount of freedom by their superiors. And then they do some transactions and it doesn't work out. What is to stop the superiors saying this person acted outside the rules of their agency? Because often the agreement between the agent and the principal might not be clear cut.
No, of course not. And I think that's a good question and goes to the heart of what the agency relationship is about, to the very basics that we started with. The relationship between the agent and the principal is a consensual relationship, and it's established, the content of its relationship, its existence, is established on the objective manifestation of parties' intention, parties' will. Objectively perceived will of the agent and objectively perceived will of the principal. So it's very difficult for a party to argue that actual intentions were very different. And that's one aspect. Of course, you might be talking about ambiguities and difficulties with interpretation of a contract between those parties, and we into a very different realm. But in that case, you first check, is there actual authority? But if not, you can still, as a third party, fall back on the apparent authority. Now, what impact that will have, liability of the principal in the relationship between principal and the agent, is another matter. So there will be a set of rights and duties between those parties too, but they are separate from the relationship with that party. Sorry, I had another question, if I may. Yeah.
I was not, so in the first energy case, is it, how come it's not that the bank is making a representation that this person wants from the bank? That's the other question. Or is it?
Well, it is the bank that makes a representation to the client that the senior manager is entitled to communicate approval of the loan to that client.
So that's apparent authority, whereas the Ocean Frost one is not, because it's not it was the agent that made the representation.
Right. Yes. So you could say so in both cases. In Ocean Frost, it's a very clear situation that there is only a statement by the agent. And you could also see the parallel that in First Energy, there is also only a statement by the agent. But the way the court was able to distinguish that case was by subsuming the facts of First Energy into the apparent, the general principles of apparent authority. So, in fact, when the Ocean Frost case was argued, that was also a question of whether there was apparent authority or not. So the basic question is similar in both cases, whether the statement by the agent that they themselves are authorised is sufficient to trigger the principles of apparent authority. And the cases on broadly similar facts seem to be decided differently, but I hope I've shown that they could be distinguished. But it's a difficult area of law, and I hope we will have a chance, all groups, whether you're with Paul Davis or myself, will have a chance to talk about that in details as well. Okay? Okay, I think I need to finish up now. We've got a couple of issues to finish up next time, which will be the question of the basis for apparent authority and the question of ratification, both of which will not take too much time. And we shall continue with the agency discussion of the other issues next time. Okay? Thanks.
You're using First Energy as an abbreviation for a case?
Okay, sorry, can I just save this? Just